This time, the chair will lay out HB 2583. The chair offers up a committee substitute to HB 2583, and the chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman, and members. That they didn't like the last bill, they'll hate this one.
We'll be great.
Currently, if the parent who pays child support is a successful business person, grossing more than $12,322.99 per month, or as a self-employed person, $13,257.36 a month, then the person's child support obligation calculations are capped at $9,200 in net income. The original bill, as introduced, raised the cap to $30,000, but the committee substitute differs from the introduced version by raising the cap only to $15,000, and that's essentially all it does.
All right, members, any questions? No? All right, at this time, we'll go to public testimony. This time, the chair calls up David Green's bill.
My name is David Green. I'm testifying on behalf of myself, and I am opposed to the bill. So this bill would increase the child support burden on many parents throughout Texas without having to show a proven need and without considering the income of the receiving parent. If the child does have more expenses than what is covered by the maximum current guideline child support, there's already a remedy for that. They can show the court under Section 154.126, application of guidelines to additional net resources, and ask the court for more. But they must have evidence of that need. Therefore, this bill is not needed and only makes the current system worse. If the purpose of this bill is to prevent a very high-income parent from not paying their fair share of child support, there is a solution to that. It's called an income sharing model, and Chairman Dunn, you have actually written that one. It's HB 2582. That one is just requesting a report on the income shares model for this state, but I would suggest passing that first and then considering changing the maximum net resources. Because currently there's just really, you shouldn't have cases where one high net earner is transferring significant amounts of child support to another high net earner. More and more these days, people with high net incomes marry people with high net incomes. And so they end up getting divorced, and there's just no sense in making those transfers without considering the income of both parents. Thank you for your time.
Thank you, Mr. Green. Any question, members? Now, thank you for your testimony. At this time, chair calls up Charles Suis.
My name is Charles Stephen Suis. I'm here to represent myself and my family, and I am against this bill. This bill simply isn't reasonable on its face. $30,000 a month is not child support. That's we're using the child support word, but it's disguising something else. I'll take questions.
Members, any questions? Thank you, Mr. Suis. Appreciate it. Oh, I'm sorry. Go ahead, Representative.
I was just going to ask you, did you understand that the original bill was to set child support at $30,000 or to use that as the number that you would multiply?
That was the cap, is my understanding. Was it $30,000 a month was the new cap?
So the way I read it, it says the guidelines in which the obligor's monthly net resources are not greater than the maximum amount of net resources to which the statutory guidelines are applicable as most recently published.
That was the guidelines most recently published, I thought, was the part that was stricken out, and we were replacing that with a $30,000 monthly cap.
Yeah. I guess I'll defer to the chairman, but that's not the way
No, that's not what the bill does at all. That's it's as he was suggesting, that was a cap on which we multiplied to determine child support, the maximum amount. But
yeah, $30,000 a month.
But that was
monthly.
Even lower.
So that's not the cap. That's what we take the multiplier factor And we, with the salary part, the income that right? And so 360,000, so you're basing it on a $360,000 income. That still seems unreasonable.
Well,
How much?
the-
6,000, is that what you said?
You said,
The committee substitute half of that to $15,000.
was
per
the
month in
committee
net resource.
substitution the bill that was linked by 9:30 a.m. this morning?
I'm sorry.
Was it you're talking about a committee substitution of the bill. It's been adjusted and then it's been reposted?
Here's a copy.
I'm not sure what you mean by reposted.
Sorry.
So I looked at the bill at 9:30 this morning because I thought the hearing was going to start at 9:30 this morning.
Yeah, but
Right.
you didn't see the committee substitute. You didn't see the substitute.
Resources. So we're essentially raising the multiplier again? I still oppose the bill.
Okay. I didn't think you'd like it, but I thought you'd
I just
like it.
wanted you to see it.
Hate it half as less.
I just wanted you to know that it's $27,000 less than what you thought.
Thank you. It is important, but I still oppose the bill.
Still oppose it, okay.
Yeah, okay, thank you.
Any other question, members?
Thank you for your patience.
Thank you,
That-
Mr. Suis.
All right, this time the chair calls Jeffrey Morgan.
Thank you very much. My name is Jeffrey Morgan. I am representing myself. I am going to be against this bill. And I'll say at the very beginning, I've never paid child support, so I don't know how the system works. So you can say, well, he's just an angry, bitter dad or something. No, that's not what I'm saying. I'm just trying to say something should be working right. So I think that child support is not supposed to be a lifestyle support. I think sometimes when we have a person who makes more money, they say, oh, we have to get more child support, and really becomes a lifestyle support. As Karen mentioned earlier, the Texas foster care system pays about $27 a day for a foster care child, and that is what they consider to be the basics for a child. And if you look at right now, what it's saying, a person who makes $180,000 would be paying $36,000 for an individual versus what? I think it was $10,800 for a foster care, so over 3 times the amount. If that's the case, maybe the state of Texas should be paying more in child care and foster care expenses. And I can say this as well because my daughter is a foster parent and has been for many times. Again, the child's needs do not change. I've also watched cases where it seemed like the judges and the attorneys really didn't understand finances nor accounting. They would look at the total revenue and not consider the cost of goods sold, not consider capital expenses. They say, well, you made so much money this month, $20,000. I say, yeah, but I have to pay loans off. I've got to do this, I've got to do that. And really, when it comes down to net income, the net income may be $4,000, but they see the $20,000 and they're like, eyes light up like that. So I don't trust the courts and the attorneys to be actually very good at financial analysis and accounting from everything that I've seen. With regard to well, maybe the child needs to have more and stuff like that. I'm sorry, that was going to refer back to the other bill, so I'll drop that section. But the other thing is that, when you're adjusting payments based only on income and not on time shared, I think that there's something wrong with that model as well. Again, people have talked about the 50-50 and stuff like that because the way that our model is supposedly justifies itself is that there's a custodial and a non-custodial. The non-custodial pays the custodial. That's only the right thing to do. And yet, I know people that have had 45 to 50, like as far as 55 for timeshare, and yet the guy or the woman who has the 45% pays the entire fee. I think there's something innately wrong about that. In fact, I have a friend who is 50-50. And he's paying not just guideline, but above guideline because he makes good money. So they're going to punish him. I think it's a punitive system. And it gives in his case, it gives the mother the ability to stay at home and just collect money. And that's all it is because it becomes lifestyle support. Anyway, I think that maybe you should look at a study for this before you just raise this amount indiscriminately. But that's really all I have to say. Nobody wants to not support their children, but they don't want to pay the other parent a nickel more than what they deserve. Isn't that right?
Well, Mr. Morgan, appreciate your testimony. Members, any questions? If not,
Thank you.
thank you, Mr. Morgan. This time the chair calls Steve Bresnen.
Thank you, Mr. Chairman. I'm going to reveal to you in the course of telling you who I am and who I'm representing and who I'm for, a little-known fact. My actual name is Stephen Green Bresnen, so I may have a relative on the other side of this issue testifying here tonight. It might be good if we straightened out a little bit of the confusion. The number right now, the monthly net resources.
Excuse me, real quick. You're
I'm sorry, I
representing-
represent the Texas Family Law Foundation. I'm for the bill.
Perfect. Now we can go.
Right now, the monthly net resources against which the guideline percentages are applied is $9,200 a month. That's where it's capped. I've passed out a comparison to you that'll show you what this bill is about in easy numbers. Before I go on, let me say that Mr. Green was almost right, that 154.123 B, 2, and 3 allow everybody's income and finances to be considered in the equation. So if you had two high wealth earners, the court could take that into account when it arrived at the final number. What this shows is that when you take the gross income and you take the deductions out that are in the statute under current law, at $9,200 net resources, that generates $1,840 for one kid at 20%, or $2,300 at two kids at 25%. But the person that makes $6,000 a month more pays the same as the person who makes the $9,200 a month. Under this bill, these payments are not for any lifestyle expenses of the ex. These are payments for the support of a child. Under this bill, one child substitute at $15,000. The benefit to the child is another $1,160. That keeps that child able to enjoy more of the kind of life that they had before the parents split, assuming the parents were ever together. And it also makes it more fair because the person with the $15,000 in net resources today pays 12% of their net resources in effect. And because that's above $9,200 cap, under the $15,000, that $3,000 comes in at 20% of net resources. And you can see from the bottom, you can see the numbers on the bottom. So under the current law, every 6 years, the cap gets changed according to the CPI automatically by Mr. Chairman, you may have carried this bill to achieve that result. In a time of high inflation, that's not keeping up.
Mr. President.
Yes, sir. And it's inherently unfair because people who make a lot of money get capped out and they get off and don't have to support their children in the lifestyle to which they should be supported.
Thank you, Mr. President. Members, any questions? Representative Cook?
Yeah, Mr. President, in this bill, does it matter? And I'm going to talk the way I guess most traditionally, with the mother being the custodial parent and
yes, sir,
the father being the non-custodial parent. Does it matter if the mother makes more than the father under this bill?
Well, it could because the court has the option under 154-123, but the mother could pay child support to the father. The family code is gender neutral. And so it could, is your scenario that she makes more money than him and she's the custodial parent? Is that your?
Correct. The answer is no. There's no, and that's, very rarely.
Not just under the guidelines,
correct,
except that's where 154-123 comes in and the court has the discretion to adjust that.
At the risk of admitting that I rarely agree with Mr. Morgan's testimony, he suggested that a study needs to take place with regard to this issue, and I know there's been some discussions, and I think someone maybe mentioned it earlier about shared shared parenting and, looking at, the actual expenses and actual incomes of both parents. And so I would support that type of concept, looking at it from a holistic standpoint, looking at both parents' incomes at the expenses. I mean, I think we all know that the most expensive expense of a young child is daycare.
Yes, sir.
I've talked about that before. But I do think it's noteworthy to look at the last part of section 154.126. And I think it's very telling from a legislative standpoint. And this is 154.126 is the application of guidelines to additional net resources. So what we're talking about here is if this person was making $30,000 that y'all were trying to get child support all the way up based upon $30,000 of net resources, but now you brought the bill back down to $15,000. But so if someone was making $20,000 and you wanted to go after more child support above and beyond the calculation for the $15,000, 154.126 would actually control, and it's the application of guidelines to additional net resources. And it says, however, in no event may the obligor be required to pay more child support than the greater of the presumptive amount or the amount equal to 100% of the proven needs of the child. And that's what we need to be talking about here. We need to be talking about what are the needs of the child, not just a number based upon what the non-custodial parent makes. And so I would encourage the chair to request that this matter be formally studied. I think it's something we should take up over the interim, and I can't support this bill. Just so you know, but sure. I would support an opportunity to study it further and look at both parents' incomes, parenting time, and the actual expenses of the child, which you talked about in your testimony.
Yes, sir.
All right, thank you.
Well, I would venture to guess we would stay actively engaged in that process, and we'd look forward to working with you on it. Yes, sir.
Thank you, Mr. President. Any other questions, members?
Thank you all for your service.
Thank you, sir. This time, Chair calls up Brandon Johnson.
Thank you, Mr. Lujan. Brandon Johnson against the bill and for myself. But I would like to mention only half as much against the bill as previous to knowing about the substitute. Thank you, Mr. Dutton. Look, it's been a long day, so I think a little bit of humor can't hurt any of us. So I've got to tell y'all, look, I didn't know about Title 4D. I didn't care about paying child support until I was limited to the very bare minimum of time with my kids. And then I had to go through the whole process. You don't know what to do, so you listen to the attorneys, you file a modification, you go to trial. I actually ended up going through the Court of Appeals to learn that process. I came down here to the Capitol. I've been invited to, with there was about 25 of us to talk with the Attorney General Ken Paxton at one time, several years ago after becoming involved. And I realized that the reason I couldn't get any more access to my kids was child support, was the Title 4D. And I've come to actually appreciate the Bresnens because they do bring up good points on a lot of things. Even though they do represent zealously, they're lobbyists, as lobbyists, they represent family law attorneys and apparently the Attorney General's office, most where they want to maximize the profits to that industry and those clients themselves. But the reality is, child support is for the benefit of the state. It is a reimbursement to the state, and it's a profit center. The benefit to the mother and the child is merely incidental to the contract. I appreciate you, Mr. Cook, for bringing up the fact, even though that I'm saying that is the case. I appreciate the fact that you did mention that the child's needs are at least in the code. And all we're really asking for is saying we want to be involved in our kids' lives. That's really it. Throw these other guys under the bus. raise it back up to 30,000 as a max. If they're not willing, if they're not fit, they're not willing, and they're not able to be fathers to their children, raise it to 45. I'm not worried about that. Unlimited, but leave us out of it. And I promise you, we can solve a lot of problems if we can incentivize fathers back in the home. Thank you, gentlemen and gentle ladies.
All right, Mr. Johnson, thank you so much. Any question, members? All right, I think that's all we have registered. Is there anyone else who wishes to testify on, for, or against HB 2583? I see none. If not, Chair recognizes Chairman Dutton to close on HB 2583.
Thank you, Mr. Chairman. I closed.
All right, committee substitute is withdrawn, and if there's no objection, HB 2583 will be left pending.
And I thank all the people who were half opposed. They were half right.